Let's get started. Welcome, everyone, to the Sexual Assault Litigation in Entertainment and Fashion. Thank you so much, everyone, for taking time to be with us today. I'm Uduak Odwak, fashion and entertainment lawyer, former fashion model, and founder of Fashion ENT Law. I bring both industry experience and civil and criminal litigation experience, including juvenile dependency, and juvenile delinquency and dependency matters involving sexual misconduct and exploitation, which informs how I approach legal issues in fashion and entertainment. And I am truly delighted to introduce today's speakers who will be joining me for this program. First up is Neda Sagafi, Joshua Kushner, and Professor Victoria Burke. A little bit about Neda. Neda Sagafi is an attorney at Panish, Shea, and Rafi Pudi, LLP, and she's a key member of the firm's sexual abuse litigation team, advocating for adult and child survivors through a compassionate, client-centered approach. Neda is also the vice chair of BHBA's litigation section, a board member with the Women's Law Association of Los Angeles, and she's barred in multiple jurisdictions, including California, New York, DC, and Maryland. Joshua Kushner is the founder and managing partner of the Kushner firm and a former sexual crimes and homicide prosecutor and big law trial attorney. Joshua's nationwide plaintiff's practice focuses on the representation of survivors of sexual assault, human trafficking, child abuse, and catastrophic injury. An active member of the National Crime Victims Bar Association, Joshua was also recognized in 2024 by the National Institute of Trial Advocacy as one of the nation's leading trial advocacy instructors for practicing attorneys and law students. Congratulations, Joshua. All right. And then finally, we've got Professor Victoria Burke, who's an adjunct associate professor at Southwestern Law School and an experienced attorney with nationally recognized expertise in intellectual property and privacy law. Since 2016, she has practiced at Scott & Scott Attorneys at Law, focusing on class action litigation involving privacy data breaches and antitrust matters in the financial services sector. We'll begin with each panelist presenting their selected case study, focusing on key legal claims and overall structure of the lawsuits. After all presentations, we'll return to the stage to discuss the broader issues raised and then open the floor for you, our audience, for your Q&A. So with that, let's get started with our first presentation by Neda Sagafi.
Hi, all. Thank you, Uduak, for that introduction. Again, my name is Neda. I am a plaintiff's sexual assault civil attorney at Panish Ravapudi in Los Angeles. I am passionate about this work, about survivors' rights and voice, and I'm so pleased to be here with you today. So thank you for taking the time out of your day. So we're all working on various case studies, and the industries that we've pointed out and highlighted, entertainment, fashion, in this particular case, sports, have these power dynamics where there is the possibility for sexual assault to thrive and a lot of concealment to occur. So the first case study that I'm going to be looking at is a civil suit against Larry Nassar and affiliated entities. If we could actually go back to the very first slide, for those of you who don't remember, Lawrence Nassar is a former osteopathic physician. He was a sports medicine doctor who worked in elite gymnastics in the United States and also worked with a number of athletes at Michigan State University. So he faced state and federal criminal charges and a number of civil suits. And again, the one that I'm highlighting today is Rachel Denhollander et al. Versus Michigan State University et al. This was a federal civil lawsuit out of the Western District of Michigan. It was a multi-plaintiff suit, and it was filed January 2017. And plaintiffs in the action included former patients, gymnasts, and minor athletes. So now we can go to the second slide and just break down the case a little bit. Now, just to let you guys know, in your materials, the entire complaint is available. I'm not going to go through each component of the complaint, but I want to highlight several big factors. If we could go to the second slide. So who were the named defendants? First and foremost, we had Nassar in his individual capacity. Now, when I file a civil lawsuit in sexual abuse, I'm considering One, is this a high-profile case? And or two, does the individual perpetrator have deep pockets? If neither, it may not make sense to name the individual perpetrator. In this particular case, we have someone who is high profile, who works with elite athletes and US Olympians. So he is named in his individual capacity. Then you will have Michigan State University and the board. Now, the board is the governing body of the university, and therefore they are named together. Nasser, having worked at Michigan State University and seen many survivor plaintiffs in his office there. You also have USA Gymnastics and also TriStars USA, which was an elite gym where Nasser frequently volunteered and also worked to treat athletes. So then we ask ourselves, what are common causes of actions in these kind of civil sexual abuse cases, and in particular in this matter? Again, I'm not going to go through all of them, but I want to highlight a few. And we note that there are state tort actions and there are also federal causes of action. And one I want to hone in on is the tort action of negligent supervision. And I'm going to talk about negligent supervision as against a minor. So negligent supervision of a minor, which is essentially a cause of action that states that the entity failed to adequately supervise the minor when it had a duty to do so. And in California, minor being someone who is younger than 18 years old. And the way that I personally established this cause of action is through asserting a special relationship, either between the entity and we're seeing these entities, MSU, the Board of Trustees, USA Gymnastics, TriStars. So either between the entity and the plaintiff's guardians, and or the entity and the third-party tortfeasor, which in this case was Nasser. As we know, there is generally no affirmative duty of care, but the special relationship doctrine creates an affirmative duty of care because, one, the plaintiff was in a particularly vulnerable position for which the defendant entity, we claim, assumed care over the plaintiff. So we are essentially saying, and you'll see this in many civil complaints for sexual abuse, we're saying, well, what you did, entity defendant, is you took care of my minor child and you represented that they would be in your care and well taken for, essentially stepping into the shoes of a parent, such that there was an affirmative duty of care. There was an affirmative duty for you to supervise my child. And so then you create that affirmative duty in the negligence context. Alternatively, for the special relationship to arise, you can say the defendant entity was in the best position to control the actions of the third-party tortfeasor. So in this case, what that would look like is you would be saying, hey, USA Gymnastics, you are in the best position to control the actions of Nasser by watching him, by overseeing him, by having direct control of him, and promulgating policies in which he should not have been able to do this. So that's really the cause of action that I want to go over. And to preserve some time, I'm going to go to the next slide. Now, in 2022, we had several athletes, we actually had 90 athletes bring a federal tort claims act as against the FBI. And those athletes included Simone Biles, Ali Reitzman, and the FTCA, or the Federal Tort Claims Act, has a procedural mechanism for filing. You have to present the administrative claim before filing a tort suit against the governmental entity. And then that has to be done within 2 years after accrual of the cause of action. Now, what is the FTCA? The FTCA basically says that when an individual is injured due to the negligence of any employee of the United States who is acting in their capacity as a government employee and negligence occurs, then there can be a viable cause of action against the US government. It's generally against the US government. And in this case, what people were saying, or survivor plaintiffs were saying, was, hey, FBI, we gave you notice that something was amiss, that this quote unquote treatment that Nasser was giving us didn't feel right. And we told you what was happening and you didn't investigate this properly, allowing this injury and this harm to continue. And so I want to go to the next slide and kind of summarize what happened in the Nasser cases. Eventually, as against MSU or Michigan State University and the board, there was a settlement of $500 million in May 2018. As against the FBI, there was a settlement of nearly $139 million in April 2024. And as against the US Gymnastics, USA Gymnastics, they filed for Chapter 11 bankruptcy, and they negotiated a settlement of $380 million. And if we go to the next slide, what's kind of the takeaway here? Institutional reform and accountability is possible. So not only did USA Gymnastics settle in terms of a monetary amount, but they also agreed to set up a restorative justice program. And under those terms, survivors would have a say in the future about how USAG deals with future allegations of sexual abuse. And because there was so much notice, there were so many complaints about what was going on with Nassar before anything was done, allegations around a cover-up, around an inadequacy of investigation, creates a higher damages story of liability. And, you know, the law is not the end-all be-all. It does create reforms, but we have to consider survivors and what they have to live with, and the mistakes that were made in the process such that harm was done upon survivors. And I think Rachel Denhollander said it best. And she wrote, "Justice has been done insofar as it can be, and it is good that we rejoice in that. But remember that tomorrow everyone wakes up still living the consequences. Don't lose that reality in the midst of sober rejoicing in the truth." So thank you all. And I'm going to go ahead and hand it over to Josh, who's going to present on Diddy.
Thank you so much, Netta. Thank you all so much for taking the time. This is such an important topic and very topical today. So anybody who takes the time to educate themselves on the state of law in this country that has the ability to benefit survivors, hats off to you and thank you. So I want to talk today about a pretty well-known case in the last year and a half. Sean Diddy Combs. If you don't have a television, you may have missed it, but if you do, you probably have quite a good sense of what the nature of the claims are. So Sean Diddy Combs, of course, is a music icon whose career has spanned decades, who ultimately was caught up in a major scandal, charged federally with multiple crimes, which we'll review on the second slide here. So, United States of America versus Sean Combs. This is the case style of the federal charges that Sean Combs faced in the Southern District of New York criminally. But I think before we get into the charges, I do think that this is an important comment regarding civil liability and the importance of civil lawyers in the criminal arena. This criminal case was spawned by the civil claims of Cassie Ventura. It was spawned by a survivor who had the courage to come forward, tell her story, and shake the trees and of the FBI and the Department of Justice. And she ultimately was the factor behind these charges. So what we're looking at ultimately as the case developed, we're talking about multiple survivors reporting a span of abuse that spanned nearly Diddy's entire career, decades, 30 years. And it was a complex network. We're talking about employees transporting individuals. We're talking about interstate travel. We're talking about corporate funded events, parties, the freak-offs that were in the news so often. And ultimately what that resulted in is it resulted in 5 federal criminal charges against Sean Combs, racketeering conspiracy, 2 counts of sex trafficking, and 2 counts of transportation for prostitution. Ultimately, again, if you have a television, you know that the guilty counts were on counts 4 and counts 5. He was found not guilty on counts 1 through 3, sentenced to 50 months in federal prison. If we could pop over to the next slide. The nature of the conduct and the reason he ultimately was charged with sex trafficking is because a lot of the stories, and whether this is no comment on whether you believe this was an overcharge or an overreach by the Department of Justice, the reports rung true of widespread, we'll call it trafficking conduct. So we talk about significant coercion and control. We'll talk about the nature of federal trafficking law right now. Coercion, control, organized encounters, extreme violence, retaliation, threats, escalating behavior, and ultimately, I think one of the things that we see in fashion, entertainment, and Hollywood, this open secret culture. There's a lot of people who claim to have known that this was happening but didn't respond, which you'll see implicates civil liability in just a moment. So understanding that this is the conduct, here's where we're at on the next slide. We're going to break down the Trafficking Victims Protection and Reauthorization Act. It's Section 1591 of the Federal Code, covers sex and labor trafficking. The key words in federal trafficking analysis, and critically, the civil elements of federal trafficking and of labor trafficking and sex trafficking, the civil elements and the criminal elements are identical. The statutes track each other. So the first element and the keywords that we see in any trafficking analysis are these words: force, fraud, or coercion. What constitutes force, fraud, and coercion, I can tell you, the case law has been developing over the last probably decade, 15 years, and it is whatever you think it is. It's wider than what you think it is, which is why it's important to consult with an experienced lawyer in this. For each element, you'll see that I am going to apply it to both Sean Combs and corporate actors, because in this case, the civil claims that have trailed Sean Combs, in addition to the criminal charges that plagued him, have not just been against him personally. In addition to other individual actors, other music stars, at one point Jay-Z was named in a suit. We're talking about a lot of corporate actors, companies as large as Epic Records and Arista Records, Bad Boy Entertainment, a lot of LLCs associated with Diddy. Those individuals are also going to be implicated here. You'll see why in the next two slides. But ultimately, the first question is force, threats, frauds, or coercion. Physical assaults, threats to careers. Doesn't have to be "I'm going to break your legs." It can be any type of. It can be financial. It can be psychological. It can be physical. There's a wide array of what can constitute force, fraud, or coercion. So the next element is on our next slide. And we're going to be talking about sexual trafficking in particular. So you're looking at a commercial sex act or anything of value. Again, the question is, well, what do we define as commercial? And what is anything of value? The answer to anything of value, which is the catch-all in this situation, is literally anything of value. Money, opportunities. I'm going to make you a star. I'll put you in a movie. You'll be on my next album. I'll get you into these parties. I'll get you drugs. There's a very wide range, but anything of value, it's a trade one for the other, a quid pro quo scenario. And this, by the way, this applies to adults. When we're talking about children, the age alone is going to be a factor of child sex trafficking, which is its own subsection of the TVPRA. Application to Combs, application to corporate actors. How are these corporate actors benefiting? I'd say anything that's directly tied to the success of a star is benefiting and receiving the same value that star would be receiving. I think that's particularly critical in this situation because when we're dealing in fashion, when we're dealing in entertainment, very rarely do we see these individual high-profile actors who are just existing on their own in this world. They are propped up by LLCs, they're propped up by record companies, by agents, by large organizations, all of whom are receiving the same benefits that star is receiving. Which brings us to our third element, on our next page, which is the knowing participation, or critically, check out that arrow, benefiting from, knowing or should have known that they were benefiting from trafficking. So civil liability is going to attach to any person or entity that benefits from participation in a trafficking venture. If anybody has seen the uptick, for example, in human trafficking litigation against motels and hotels, this is their knowing benefit. When they turn a blind eye to what's happening in these rooms, when they see these girls coming in and out, they are benefiting from it, even if it's just by receiving $50 for the room rental that evening. That's knowing benefiting. Same concept. So obviously the argument would be that Combs he's an active participant. He doesn't need to be a knowing beneficiary. He is the trafficker in this situation. Arguably, other individuals are the traffickers. But when you apply to corporate actors, you're talking about any individual who's providing, and these are the allegations in these civil suits, providing transportation, housing, security, event coordination, travel, people who are providing drugs and alcohol, people who are moving people from one location to another. Arguably, the failure to intervene, despite your longstanding knowledge, knowing that this is happening, knowing this is happening for 30 years, doing nothing but taking your paycheck or taking your tax benefits as a corporate entity, ultimately, arguably, benefiting from trafficking ventures. Which brings us to our final slide, I believe. So our lessons in civil liability is this. Where conduct fits a federal trafficking framework, you can bring these claims federally in any jurisdiction. A couple of just general comments. While punitive damages are not included in the statute itself, there is not a federal court in this country that has not found, I believe every circuit at this point has found in at least one case that punitive damages are available under the statute. In these situations, there's usually a strong basis for vicarious liability when we're talking about these additional corporate actors. You are not limited to your trafficking claims. There are definitely claims that trail these, and most trafficking claims are brought alongside vicarious liability claims, negligent supervision, negligent hiring, negligent retention, aiding and abetting claims. And when you're dealing with these larger actors or these sort of complicit parties, that comes along with a lot of evidence, travel logs, communications, contracts, NDAs. It also often, if you can shake the trees like Cassie Ventura did, it also often comes with the benefit of trailing behind an FBI investigation or a state trafficking investigation. But ultimately, what I think it shows is that these organizations, these LLCs, these entities exist alongside and behind these actors in the fashion and entertainment and sports and music industries. They are going to be held responsible as they should be. And the TVPRA provides a good opportunity for them to do that. With that, I will turn it over to Victoria Burke.
Thank you so much. Okay, I'm going to be covering the case studies of Bruce Weber and Mario Testino. These are two highly regarded fashion photographers. Anna Wintour, editor of Vogue, had said these were her, some of her best friends. And what happened was, first of all, we had the Me Too movement that really, caught fire around 2016 of Harvey Weinstein. And this came about in 2018 when numerous male models are saying, hey, I was like sexually harassed, sexually assaulted, touched inappropriately by these two very esteemed photographers. And you have to realize when you're in modeling, you could be in very vulnerable positions, and a lot of times they're young and they may or may not know what is appropriate, such as like they might be touching you to adjust you, or like with Bruce Weber, if you could advance the slide. With Bruce Weber, he would engage in say we're going to do some of these breathing exercises together, and he would use it as a way to inappropriately touch the models. And at one point in, I believe it was 2018, a whole bunch of people came forward, and in 2020, Bruce was actually sued in court. Next slide. So he was brought forward by Jason Boyce and then 10 non-party accusers. And the causes of action in New York were New York State human rights law, New York City human rights law for like sex trafficking under the Trafficking Victims Protection Act. Now, a lot of times you'll see with these cases, they do not go forward. They usually end in a settlement. And especially when they get a lot of press, a lot of times someone wants them to go away. And so you never really see how these laws play out. And can you advance one more? And with Mario Testino, I don't believe there was a case brought against him, but there were accusations. And the ramifications of these actions were no one wanted to work with these photographers anymore. Anna Wintour had said that Condé Nast would no longer be employing them, even though, she said these are some of my good friends, but like we have to be cautious and, believe survivors. And, this is how it was for a while. But as we're noticing now with a lot of the effects of like the Me Too movement is it didn't always stick. And they're starting to make a comeback, such as Bruce Weber. If you could advance it one more. He's having a quiet return. He's offering to work for free. And a lot of places are like, wow, he's such an expert photographer and he's willing to work for free. That sounds pretty good to us. And so what you'll see here is like, you're having to inform models before that they go to assignments with Bruce Weber of these allegations. But I'm sure that probably make a model feel very, unsure how to say yes or no to this because, as a photographer, if your agency is sending you out there saying like, are you comfortable with it? Like, are you in a position to say no? So unfortunately, like a lot of people are put in these, positions without something to like feel secure. There's like no telling them to have like someone else present to make sure everything is fine. And so next slide. So I was curious about how would this play out in today's legal landscape. And what's interesting is what we saw in like the Me Too movement is the press covered how great it was when so many survivors came forward and they told their story. And we saw people like Harvey Weinstein and other people be taken down. We're like, yes, this is good. People are speaking out. But what the press didn't cover as much is what came after it. And what came after it was a wave of defamation lawsuits used to silence people speaking out, the survivors. And usually with the survivors, oftentimes there's an imbalance of power and money. And what happened with these lawsuits is that it's very hard to prove defamation in these cases because, a lot of times they're many years ago, there's no evidence remaining, no one else was there. It's he said, she said, two people go in the room, two people exit. They both have two different versions about what happened. So these cases usually are not winnable, but they're used to intimidate and bully and to just shut down the survivor speak out because it's cheaper to go silent because these defamation lawsuits oftentimes cost 5, 6, even 7 figures, and they often take like 5 years to resolve, and it's so much cheaper to go silent. And I had something that happened to me years ago, and when I was in this position of I wanted to speak out, I remember a friend of mine from law school had said to me, don't speak out, don't use your abuser's name, any identifiers, you could be sued for defamation. And I remember thinking, like, that's crazy. Like, what? And she said, please just look it up in the wake of Me Too, what happened. So I did start doing all this research and I was outraged by this huge wave that was happening. So I decided to change the law. And so I came up with AB 933, which basically is called the Speak Your Truth Act. And it was made into law, enacted in 2023 in California. It's now 4 states have adopted it and it's moving nationwide. What it does is if a survivor is sued for defamation, it ensures that like if it cannot be shown that the survivor spoke with malice, that the survivor can recover attorney fees, and in California, treble damages and potentially punitive damages. And you're seeing this bill, which it started to get like, catch fire this year. Blake Lively used it as a defense with Justin Baldoni in the defamation case. And so I've had to see my bill be misspoke about all over social media and people not quite understanding the mechanics of how it works. Because even now, although the defamation claim has ended, she still is able to claim damages of attorney fees and possible trouble damages and potentially punitive damages because of my bill. And that still needs to be adjudicated. So I'm seeing my bills being applied quite often now. I was speaking to attorney Allison Anderson, who represented the victims of Danny Masterson, and she said she's been applying my bill since March. And what she's seen is there's coming in the threat to a client of hers, a survivor, speaking out of like, well, we're going to sue for defamation if they don't stop talking. She's like, well, go ahead. If you can't prove malice, you're going to have to pay their attorney fees and any of their actual damages, which would be triple and potential punitive. So if you're willing to do that, let's go. And all of these cases are going away. So it's having a chilling effect on those who want to bully while still preserving the ability of someone who's falsely accused to bring forward a defamation claim so long as they can prove malice. And so that is currently moving nationwide. Last year it was introduced in 16 states. Certain states take several years to get it passed. It's been introduced in New York. It was mentioned with articles about Cuomo. Was brought up oftentimes that, how would that bill affect him with his suing his survivor, threatening to sue his survivors, speaking out for defamation. So it's having quite an impact in significant places across the nation. Because if you think about it, with the Blake Lively trial, originally Justin Baldoni responded, Blake Lively wanted New York law. And he said, no, 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 I want California law as the contrast state. She was like, okay, well, then we're going to apply this bill, which was just recently passed in California. So you have to think about your client about what choice of law that they might want to use in a case like this, because in this state, this law is available. So depending on which side your client's on, might impact which state you wishes the law to be applied. So that is right now how we see with the landscape would it apply is that maybe nowadays the photographers would have tried to sue for defamation, the models, but now we're seeing that many people are able to use my bill, which is AB 933 or CA 47.1, to say, okay, to counter any threat of a defamation lawsuit that's being weaponized. They could say, like, that's fine. Here are the consequences if you can't show malice. So that's the new landscape. Thank you so much.
Thank you so much, Victoria. And before I get into my own discussion and presentation, I first have to highlight a few things that really stuck out to me of what everyone said. And I'll start with Victoria. In a different conversation just yesterday, I was,
Excuse me, Uduak, it looks like your camera's not on.
oh, my apologies. Can everybody see me now?
Yes.
Yeah, okay. Thank you so much, Susie. So in a different conversation yesterday, I was saying and lamenting the plight of the legal industry as a whole, legal profession and attorneys. When you look at the current climate that we have and the media narrative and the public's distrust of who we are as attorneys. And the idea that it's funny how we are responsible for giving voices to the voiceless, but when you really peel the layers behind, you really see that we don't really have a voice. I find that that applies in the entertainment industry as well, or we think we don't have a voice. And what Victoria has done is underscore that not only do we have a voice, we have a duty and obligation to do something about it through the notes I took that she was just talking about, Speak Your Truth Act, right? So and you're going to see as I present that you can no longer sort of take an arm's length approach and say, oh, let me sit back. I see all this toxicity, as Josh highlighted so well, open secret culture that's occurring, and do nothing about it. You actually could potentially be pulled into having to deal with legal liability. I also liked what Netta said about negligent supervision of a minor that is rampant in the entire entertainment industry and of course, and fashion. And of course, as you see these cases, they're going way back when people were minors. So let me actually use my experience, industry experience. I started modeling at 14 years old. And the sexual harassment that I experienced in modeling, it was so commonplace, open secret, not only me, my colleagues. And often, particularly when you look at the fashion industry, there's an emphasis on women and also the entertainment culture as a whole. Our boys and men are really suffering. And I appreciate that Victoria underscored that sexual harassment that did not stop. And of course, in that space also, you hear about sexual assault towards other colleagues in the film. And if you're working in fashion, necessarily at some point, all of the creative arts are going to intersect. So I got into film and I got into music. It never stopped, right? Until I really started to obviously assert myself as I grew older in the industry because everybody, that culture of silence, are you going to lose the opportunity? What's going to happen to you? Is anyone going to believe you? It's really, really, really rampant and also quite strong. Having said that, let me transition to my actual presentation. We'll start with the first slide. And so one of the reasons I emphasize my personal experience is often I'm asked, is it really true what everyone is saying? It is so true and beyond. Film industry experience, as I said, sexual harassment, music industry, same thing. And to underscore that, we're looking at the McGowan versus Weinstein case, et al., the anatomy of a Me Too era racketeering lawsuit. Remember when this case broke, everybody started to say, me too, me too. And it seemed like, wow, this was really going on. Yes, it is. Let's start first with the parties, with the McGowan versus Weinstein case. First thing to note is that the plaintiff here is Rose McGowan. She's an actor. She's the author of Brave, which tells her story of allegedly being raped by the defendant Weinstein. And she's also a big advocate for industry reform on sexual harassment and sexual assault. The defendants here, as pled in the original complaint, was Harvey Weinstein, David Boies, and Boies Sheila Flexner LLP. David Boies as a lawyer, Lisa Bloom and the Bloom firm, BC Strategies Limited doing business as Black Cube, which was a security agency hired allegedly by the attorneys in order to supposedly track Rose McGowan, among other things that she mentioned that they did that was even more egregious. What I want to underscore, particularly with this slide, is that David Boies is sued in his individual capacity and as an agent acting on behalf of his law firm. And his law firm is also pulled into the litigation. The same holds for Lisa Bloom. And if you're not familiar, maybe with Lisa Bloom, she's Gloria Allred's daughter. And she, along with her mother, are known as advocates for sexual assault victims, especially women. To quote from page 16 of the complaint, the plaintiff said Bloom primarily represented women who accused celebrities and other prominent men of sexual harassment and assault, including President Donald Trump and then Fox News anchor Bill O'Reilly. So, as a lawyer, you may be exposed to legal liability, disciplinary consequences, and one of the ways to assess that is to look at whether you knew or had a strong reason to believe that, for example, minors were being abused or placed in danger, women were experiencing sexual harassment or assault, or that there were ongoing violations of employment or safety laws. Again, you can no longer sort of take an arm's length to this realities. Let's move on to the next slide of where we talk about the civil litigation landscape against Harvey Weinstein. Dozens of lawsuits were filed across multiple jurisdictions. However, what I could find in terms of well-documented suits include the Doe versus Weinstein matter that you see here on your screen, the Ashley Judd versus Weinstein, and then the McGowan versus Weinstein et al., which is what we're focusing on. There were also criminal prosecutions in New York City and Los Angeles that occurred separately. That's not part of the analysis. The focus here is more on the civil. All right. We already covered the parties, I believe. Let's get into the case theory. For the case theory, McGowan's point was that she claimed under the RICO statute that defendants formed and operated a Weinstein protection enterprise to spy on her and deceive her, to obtain and exploit her Brave manuscript, which was sort of this tell-all included of what had happened to her, and also interfered with the publication to discredit her rape allegations. So lawyers are sometimes named in lawsuits, even if they were not abusers. And because, why so? It's because they allegedly are helping with creating the system that allows abuse to continue. So ask yourself, are you drafting settlement agreements to hide abuse? Are you threatening or pressuring victims into silence? Are you helping to destroy or hide evidence? Are you transferring abusers or protecting them from internal consequences? If you're doing such thing, there might be a time of reckoning. So let's go to the pleading strategy for this particular matter. First, as with any other complaint you file, you want to ensure that the proper caption is there. Jury demand in this instance is a jurisdictional and venue question, of course, that you must address. In this instance, federal question addressed RICO, wiretap, the Wiretap Act, the supplemental state claims that also should be addressed in that complaint. The parties, I loved how Neda talked about evaluating deep pockets. We all know that's sort of a standard important thing to evaluate. But for newer attorneys, if you're getting into it and filing such complaint, be aware of that to know where the deep pockets are. Detailed factual background, always important. And if you look at the complaint in your packet that you should have received, it should be about 72 pages of very detailed facts on what happened, how it happened, among other things. Next, you look at specifically if you have a RICO claim, you have to have it pled with very, very detailed facts. And part of that is establishing RICO enterprise and the Predicate Act section. Also, the causes of action that was addressed here was the multi-counts of RICO, Wiretap Act, the fraud, the Bain Act, the computer crimes, the conversion, the intentional infliction of emotional distress, the negligence, and the prayer for relief. Essentially, McGowan was saying Weinstein and his associates orchestrated efforts through their legal counsel and their investigators to prevent her from publishing her book, to leak damaging information about her, including drug-related charges, to silence and intimidate her, all to protect Weinstein's interests. And she claims that those actions constituted an enterprise and the Weinstein enterprise, the Weinstein protection enterprise, and that the defendants committed multiple predicate acts, which was the fraud, the Wiretap Acts I had already addressed over a period of time. Next slide, please, on the litigation outcome. So the litigation outcome of what happened in this case was there was the motion to dismiss granted in part and denied in part. The fraud-based claim survived, and several statutory claims, including the RICO claim, was dismissed with leave to amend. That was in 2020. Subsequently, in 2021, there was an amended RICO allegations that was still insufficient because of how high that threshold is to meet for RICO claims and the elements that must be satisfied. And after that, McGowan proceeded pro se because her attorneys withdrew and she missed a supplemental briefing deadline. And ultimately, the court dismissed the action. The RICO claims were also dismissed with prejudice, meaning that she can't come back and refile those matters. So the emphasis for us is really to unpack a lot of conversation here. And so on the ethics and industry implications. So next slide, please, as we begin to get ready to have even further discussions. What are the ethics and industry implications here? I think for me, the central thing here is highlighting what responsibilities do lawyers have when protecting powerful clients. It doesn't even have to be powerful nationwide clients, when protecting clients that might be really inflicting harm on victims that we become aware of, and where is that ethical line? So how the allegations were used in this particular matter, use of private intelligence firms and covert surveillance directed by lawyers or allegedly directed by lawyers, blending of legal strategy, PR, and undercover operations, litigation tactics functioning as intimidation rather than advocacy. That was part of the allegation. Non-disclosure agreements and settlements discuss as potential silences of accusers and the resulting impact on the public trust in lawyers and the justice system. So on that note, I will make a transition and pose my first question to Josh, actually. Josh, what responsibilities do lawyers have when protecting powerful clients?
So I'll say this. Most of my practice is going to focus on, we'll say the underdog, the survivor, but that's not saying that there aren't powerful individuals who are also victimized. I think a lot of times that's overlooked. But I think, the duty owed is the duty owed to any client, right? It's zealous representation, it's zealous advocacy within the ethics of our profession. And as soon as this goes, I guess, particularly for any new lawyers, young lawyers on the on this meeting, as soon as you start questioning if something's a close call, should I do this? Should I not? I'll save you the call to the bar hotline and say, don't do it, right? We're human beings. We have a duty, but ultimately, if there's a lot of gray. This is sort of, I guess, the lesson. There's a lot of gray in our profession. There's also a lot of black and white. And I think that one of the critical things that to do is when you see the black and white, make the right decision and make the right call. And then when there's gray, you deal with it and you speak to colleagues that you have, but your moral compass is something that you just can't lose in this type of litigation.
Okay, so let me go to Victoria then. The question, Josh, you said when there's gray. So Victoria, when there's gray, how do you handle that? Particularly, I would say, what effective counter strategies can you, create for a culture of silence that normalizes internal and external reporting? And then one of the reasons I ask also, you talk about how in the modeling industry, which is so true, you're being touched for feedings, among other things. And so you're not even connecting the dots that is happening per se, even though it might feel uncomfortable for you. So what counter strategies would you say that lawyers should be thinking about and employing?
I think maybe urge different industries to start educating what are the boundaries and what can be, and maybe have chaperones, urge something like that in different industries that have, intimate actors, like, where you're modeling and touching people, because we're starting to see, are they called intimate coordinators for movies where, so we're starting to see where actors used to just have to tolerate it, some of them, I could think of the movies in the past where, they were really bad to different women and stuff like that. And now I have an intimacy coordinator to, if you have any issues, you can consult them and be like, I'm not comfortable. And I think that's really good. And I think that should be spread throughout the industry. And I think people should have an environment where they're encouraged to come forward. However, I do feel that if you have a story to tell, it would be beneficial to pause and consult an attorney, because not every state has, like my bill, like the Speak Your Truth Act, and so you can be hit with a defamation suit that takes long. So you have to think about, is there another way I could speak about it without being sued? So I would take a pause if I, was counseling a client and just say, just so you know, these are the consequences if you name the person or give any identifiers and you're not protecting this in this particular area, but this is how you can still tell your story in this way. So maybe like if some people had to redo when they did hashtag Me Too and told their story on Twitter, that maybe they would have left out some identifying details and said that if they were not prepared to handle a defamation suit that came, afterwards. But I've seen more where people are having like a network where I forgot what it's called. Shoot. I'll have to remember it. Where if for on college campuses that you can now sign up if you have been sexually assaulted, and if someone else has been sexually assaulted by your abuser, you're connected, and it's anonymous until then. So then, like, only at that point would you guys connect to like discuss if there's an abuse case. So there, people are finding ways where they can come forward that where it is in a somewhat protected environment.
Wow, very, very interesting. Let me transition to Neda. That's interesting what's happening on college campuses. Um, Victoria brought a very important point about how you're counseling your clients. So, two last questions before we go to the audience, and then we can always come back and answer more, discuss some more and unpack some more. Where, Netta, would you say you draw the line between confidentiality versus being complicit? That's a hard line that a lot of attorneys are always trying to figure out, all of us included. So, what would you recommend would be the approach?
Sure. So when I think about confidentiality, I'm thinking about our ethical duties and responsibilities of confidentiality to our clients. And so the question that I ask myself is the confidentiality serving a legitimate client interest, or is it primarily serving to silence disclosure of wrongdoing and protect the wrongdoer rather than protecting the victim? So in thinking about confidentiality versus complicity, the question becomes, are we enabling misconduct in a manner that doesn't actually abide by our responsibilities of confidentiality per our ethical requirements as attorneys? And confidentiality is essential as well, but it doesn't override all other ethical concerns. So, a few points I want to add here. If you represent, let's say, a studio, a brand, a team, and you become aware of patterns of misconduct, our responsibility is to ensure that we're not simply enabling the concealment of abuse. It's our responsibility to consider whether we need to advise the organization to adopt independent and impartial outside external investigations, disclosure obligations, and systemic reforms. And if you find that your role is becoming a participant in concealment of wrongdoing, there are mechanisms of withdrawing under our ethical rules, right? In California, Rule 1.16. And, another thing that I want to bring up is reviewing settlements, particularly in civil lawsuits. In thinking about NDAs, non-disclosure agreements, you have to make sure that the confidentiality clauses don't run afoul of statutory prohibitions. In California, the California Code of Civil Procedures 1001 and 1002 essentially say that a settlement agreement in a civil lawsuit cannot prohibit a survivor from providing the factual claims of sexual assault or harassment. So being really careful that you as an attorney are reviewing those settlement agreements as well.
Okay, I want to come back to you, Netta, on AB 250 that's just been recently enacted and have you sort of spell that out. But before I do, you mentioned something that maybe, Josh, it would be interesting to see your perspective on it. Sort of like we have a duty to report, etc. I know most of my colleagues in the entertainment music space are going to say easier said than done. Depending on the genre, and the clients you're representing, it truly is a very toxic culture at the core. I've talked to colleagues that say they just feel not only so uncomfortable, they don't sleep well at night. And they can't wait to just get out of that space. But they've got to worry about bills. They've got to worry about all these other things. And beyond that, they almost feel like, yes, it's happening, but it's not my place to move forward with, particularly outing my client, if you will. So, Josh, you have extensive experience more on the prosecuting side. Now you're doing the civil plaintiff side. How do we handle all of this? Still trying to do the right thing, but then sometimes depending on the culture of the industry we're representing and the clients we're representing, it's just a different ball game from a practical standpoint.
Yeah, I, I'll say this. I'll fall back, and I might be oversimplifying this a little bit. I'll fall back on my first answer a little bit here. If you feel that you can't navigate sort of the moral complexities of this, and this is just an industry that you feel like your hands are tied, or you're not sure that you can navigate sort of the practical or professional balances of reporting, of dealing with clients, of sort of working in a space where this type of abuse exists and you know it and you see it. If you can't do that sort of personally, professionally, I'd say go ahead and just go into transactional work. And that's that. And not saying that transactional lawyers aren't around this and don't see it and don't have the same responsibilities. Now, when we're talking about, obviously, when we're talking about client confidentialities and things like that, we're lawyers. We're bound by certain rules and certain ethics and things like that. But I guess the way that you tie those two things together is to say, we know there's a reason that this is a panel, right, that exists in 2025, right? Because we know what's happening. The light has been shown. It continues to be shown. We're going to see In whatever's going to happen in the next few weeks, I think we're going to see a lot of things exposed and a lot of names out there and a lot of you know, people spiraling and world spinning. And I think one of the things that you're going to find is you're going to find that those people didn't operate in a vacuum, right? There were people out there. They have lawyers, they have representatives, they have like Sean Diddy Combs, like Bad Boy Entertainment. They have LLCs, they have people propping them up. These people don't exist in the ether, right? The next time I see a multi-millionaire high fashion entertainment powerhouse who doesn't have a massive team behind him or strategic agency or strategic corporation, that will be the first. So if you have the ability to operate in that world and you can walk that moral line and go to sleep at night and sleep, and as long as you're acting ethically, I say, go for it. But again, to the younger lawyers, your reputation is everything in the law. As soon as you make a misstep, it will follow you forever, I promise. So if you can do it, do it. If you can do it and if you have client confidences, which you will have, I promise you, there are client confidences that I have that I wish I didn't. And I have been representing plaintiffs and survivors and victims my whole life, and I still have those. If you don't think that you can operate with those on your conscience, go into it for your own mental health, go into a different industry. But outside of that, again, there are certain things that are just black and white, and your own moral compass is going to be your guide.
Excellent. Thank you so much. We've got a few questions that I see, which is why I'm knowingly continuing with the panel to unpack a little bit. But I'll wrap it up with this final question with Netta, and then we'll go into the two questions posed by Nicole Sass. So over to you, Netta, specifically. AB 250, Assembly Bill 250 is now being passed, and it supposedly will have an impact on sexual abuse litigation. Could you just give us the key features or break any additional information that will be helpful to our audience?
Yeah, I'll break it down really quickly. So Assembly Bill 250 basically amends the statute of limitations in 340.16, CCP 340.16, to revive claims for adult sexual assault for survivors whose claims were previously time barred in the civil context. So the revival period, it is effective January 1st, 2026 through December 31st, 2027. So basically, for adult sexual abuse matters in the civil context that were previously time barred, this basically creates a window in which you can bring the claim. It does not include public entities. So if one of your defendants, for instance, is a public school district, that would not be able to be named in this look back period. So you can name an individual perpetrator, you can name a private institution, but a cover-up should be alleged as to the entity. So that's AB 250, which excitingly is coming into place and effective January 1st, 2026.
Thank you so much for that. Let's go to the questions posed. I think I'll start with the one from Giacomo Jack Russo, and then we'll go to the longer one from Nicole. So is Boyes and his firm doing the same pattern as in the Terranos Elizabeth Holmes case, or is this just all zealous advice? That's the trick, Jack, right? That's the challenge of that case. And the fact that it ultimately got dismissed, the McGowan case, one could argue whether it's Lisa Bloom's firm or Boy's firm, that it's in fact, David Boy's firm, that it's in fact legal advice. We're doing what any other attorney would do. The first thing you do is obviously consult with your client. Your client is saying this is truthfully, I didn't do those things, they're false, etc. You conduct an investigation. Of course, you have to conduct an investigation as part of your duty, among other things. But it appears that that matter never went to trial. So in terms, a lot of it would be speculating, right? But if it did, and then we would obviously find something more tangible that we can hang on to. But with the Terranos Elizabeth Holmes case, actually a very close friend of mine of over 20 years was one of the part of the prosecuting team for that Elizabeth Holmes matter. And it appeared, well, depend on the industry, but it appeared based on what we see. When I say depend on the industry, some feel that it wasn't any different because she was a woman, as she was claiming that's why she ended up having to deal with this. But if it was a man who convinced investors to invest this sum of money for this potential solution that could really save lives, it'd be a different story. But to your point again, I think that that's what we won't per se know. I think David Boies could argue convincingly and persuasively, and I think that's why the court on the RICO claims that you haven't really showed true connection in establishing those elements to show that in fact that was a racketeering enterprise that you're claiming. Let's go to Nicole Sass' question. She says, "How about digital sexual abuse via AI and revenge porn?"
Can I just
When
say
Oh, sure. You want to take this one?
yes?
Okay, so let me read it out for anyone else that hasn't seen it. How about digital sexual abuse via AI and revenge porn? When police department refuse investigation, when organizations protect the abuser, and the victim is labeled crazy, and her fake deep photos and fake revenge porn videos spread all over the internet. Please mention the President's Take It Down Act that went into effect May 2025. Over to you, Victoria.
Okay, it's interesting because I remember with the organization RAIN, who's very big advocate of victims of sexual assault and abuse, when I was asking them to vet my bill in 2022, an early draft of it, they had asked me, "What do you think about revenge porn? How would you go about like fixing this?" And I said, "Oh, you could very like I said maybe say copyright that you participated, so you have rights." I said, "But you're probably just going to have to just write a bill." And so they did. They ended up working with other people to get this bill passed. And what it does is you can now go to like different social media platforms that have, posted any revenge porn or AI porn, and they have 48 hours to take it down. And, they also have federal penalties for anyone who has done this, which is like you could be put in jail for 2 years. And if it's a child, 3 years. And it's the FTC that is the one who enforces this.
Thank you. I'll allow chime in from Josh and Netta, and then we'll wrap it up with our next.
I'll follow up on that. Not so much on the AI, but I do maintain a niche practice in digital voyeurism. I don't, I think the obviously our terms are changing all the time. I think it's non-consensual sharing of private imagery as opposed to revenge porn, whatever the term is. Critically, one thing that I think people overlook, and it's not a claim that's often held, but the Violence Against Women Reauthorization Act of 2022 actually set statutory damages of $150,000 per image for the distribution of non-consensual private imagery. So your ex-boyfriend goes out and sends 3 pictures that were meant for your ex-boyfriend at the time because you split. It's $450,000. Does he have it? I don't know. That being said, did I have a case against a hotel chain recently where a nasty boyfriend sent private pictures of his girlfriend to the boss, and then the boss forwarded them to another person in the company, and ultimately put his hotel on the hook for transmission of private imagery at $150,000 a pop? Yes, I did. There's an argument that the posting of those those images, for example, to any cloud-based sharing site is the sharing of the imagery, and the movement of those images by any cloud-based server is the sharing of the imagery. So the law is very much developing in that area, but the Violence Against Women Act of 2022 actually did quite a bit for civil victims of revenge porn.
That is so interesting when you talk about the sharing through the cloud, because down the line you could see potential liability pulling in the tech companies. So that's fascinating.
Yeah.
If they continue to go under the Communications Decency Section 230 Act kind of situation. Okay, so let's close
from
it
the
up.
90s.
Yeah, right.
Yeah, before the internet was the internet, but who are we?
Okay, thank you so much for that. Let's answer Annette's final question. She says, could anyone explain why McGowan could not find substitute counsel? Seems like she had a very strong case. I'll let my colleagues start off and then I'll close it out since I brought up that case. Anyone? Okay, then let me go since I delved into. That's a fascinating question. I was also curious as I researched it why they even, withdrew in the first place, because I couldn't necessarily find any information about it. It does appear that she has a pretty strong case. Usually, I mean, the finances involved in litigation, as we already know, is just humongous. And with you know, such detailed pleading and the factual statement, it seemed like her attorneys were very invested in the first place. When you now lose those attorneys, sometimes it's very hard to find another one to take on your matter, especially if you don't have a budget for it. And if you're going against very, very powerful people who will bombard you in the discovery process with all kinds of paperwork and really try to just make your life miserable. I would also add that it's one thing to go against Weinstein, but then you're now adding law firms to it where their reputation matters, their license matters. It's definitely a uphill battle. So I'm thinking, I don't know, that it's really from a reality of just a budget issue on the part of the plaintiff, and secondly, on the part of the defendants taking on the business, right? You're not going to run your law firm out of business just because you're trying to represent one client. And it doesn't matter the size. Sometimes even the larger the size of the firm, the more expenses you deal with, plus media scrutiny, etc. So I think I'm guessing from a practical standpoint, budget issue both on her end and then potential counsel looking at the cost benefit and just say, no, it's not worth getting entangled and all of that. With that, we conclude this wonderful panel. I would say, to my knowledge, and I've attended a lot of panels within and outside of BHBA, I think this is the first I've ever seen in the industry, and I've been in the industry now for about 30 years, that I've ever seen anything on this topic. I want to thank Netta and the entire BHBA litigation section, Rachel included, myself included, as we came up with this to say, you know what, let's start changing this narrative. Thank you to our entertainment and fashion colleagues also that are joining on this. And we really appreciate you. Thank you, Josh, Victoria, Netta. Everybody was excellent. Until next time, we'll see you. And thank you so much for joining us. Meeting is
Thank you.
over. Thank you.